This channel does not promote any violent, harmful, or illegal activities. All content provided by this channel is meant for an educational purpose only.
Wait, please, Manoj.
May it please your lordship, Manoj. It will be on behalf of the state respondent. I'm being led by ASG Raju sir, Manoj, who is online.
Yes. Now, Mr. Shankar Narayan,
Yes, but
yes. You want to make further submission?
Manoj, I don't think I really need to respond to anything.
Anything left?
I don't think there is much left, Manoj.
My perception,
I
having
wanted half of my submission,
Yes, Manoj. I don't want to take more of the
occasion. That
Yes,
was on 30th July 2026.
correct.
No, I'm not completed.
I don't want to take more of the court's time on this. I just have submitted that note, my lord. That may be with your lordships. On the last occasion itself. That
Yes.
note had been submitted.
Yes, that was filed. It was lying with the record.
Yes.
We have not been handed over with a copy of the note, Manoj.
Yes.
In the event, Manoj, we need to take
No, it's not a written note. It is for the consumption of the court. Yes.
And Manoj, I want to once again
Manoj, may I
confirm that
continue?
the respondents have handed up an updated list of the FIRs which has been received by us. There are 16 FIRs. You have taken note of that on the last occasion, Manoj. I'm grateful.
Yes, that is in a tabular form. This was filed.
Yes,
Manoj,
yes,
we have handed up
I've
the
been
list,
told
Manoj, to them.
There's a revised, more detailed list.
Just a minute. Let me find it out. Yes, I remember.
That 16, you have noted it in your last order, Manoj, of 6th August. Para 6 of the last order.
I'm giving another copy, Malad. I'm giving.
Just a minute. That copy is there. Yes, this one.
No, my learned senior is talking about that
This is the
FIR which has been supplied by them.
My lords will recall the direction of the
No,
court.
in this chart there are 11.
Yes.
There are 11.
Yes. Now, that was based on a surmise about what the actual complaints and FIRs were, my lords.
Now,
Your lordships-
subsequently, in terms of the order passed on the last occasion, they
Correct.
compared with this
Yes.
direction and the chart was given.
Correct. And you have taken note of it in your last order of 6th August 2026 at para 6.
Those.
This is the chart, Mr. Nondi.
No, Malad. Malad, this one.
Manoj, I have handed them, Manoj, a single page, Manoj, on the last occasion containing the details of the FIR.
Just give it. Find
I have a chart, Malad. I can.
out of this 16 FIRs, one is Bidhannagar police station case number 75. So far I remember.
Of this petition.
That is already questioned and petitioner is enjoying an interim order.
Malad. Pursuant to
Now,
lordship's order.
apart from this, all 15s are not disclosed at the time of filing of this writ petition. So far, I have learned
That is correct.
representing
correct.
the petitioner.
That
Now,
is correct.
probably five criminal prosecutions were disclosed in the writ petition, out
Yes.
of which three particulars of three criminal prosecutions were disclosed and matter was heard. Subsequently, chart was provided giving
Yes.
details of 16 FIRs.
Malad.
Now,
Yes,
so far the present matter is concerned, excluding because there is no further order need be passed on
Yes.
Bidhannagar Cybercrime Police Station FIR number 75 because
Yes.
there another writ petition is pending.
Yes.
So far, the second another criminal revisional application is pending, where petitioner is enjoying an interim protection. Which one is that matter?
He has challenged,
Just a minute.
not Bidhannagar.
Which one is that matter?
Malad will kindly peruse page
That
13
is-
of the
No,
writ.
from the chart. That will be helpful.
That is here street, Manoj.
Yes.
That is Hare Street. Yes, that is just a minute.
But here he has challenged, Manoj, Bhawanipur, not Bidhannagar, Manoj. He has challenged Bhawanipur.
So within 16, Hare Street is not there.
No. Even Bidhannagar is not there.
Hare Street, Malad, it's a different application. Pursuant to that, we have filed a CRR.
Yes,
That is
so
fine.
that prosecution is not disclosed out of 16 in this.
No,
chart of
13,
16.
item number 13.
13. Just a minute. Yes. So 13 and 14, no order is required. Petitioner is already enjoying interim protection.
Hello.
So rest of the 14 matters, you are seeking order. Yes.
But I'm being led by.
Another writ is also pending in your lordship's list.
That's item 83, my lords.
There are also some of the matters.
Some of the matters.
Some of the prosecutions.
My update-
So in this writ petition, court
Three.
is
Only
then
three.
Mr. Shankar Narayanan, in this writ petition, court is confining itself to 3.
Yes.
That's correct. That's correct. And you've made note of it, my lords, in your order
Yes.
of 30th July. You've mentioned the 3.
Order which will be passed in this writ petition, that will be considered in the subsequent writ petition file challenging other
That's
prosecutions.
correct. I'm grateful. That's
Yes.
Yes. But I'm being
Yes,
led by.
Mr. Raju.
Yes, my lord. May I point out, my lord?
Yes. Very precisely, I have heard you extensively on last occasion.
Yes, I'll be
Yes.
very precise. The only thing, my lord, my
Yes.
first submission is that if an FIR discloses a cognizable offence,
And court, Mr. Shankar Narayanan, court wants to see the order passed yesterday by the Honorable Supreme Court
Yes,
with regard to treatment of the petitioner.
correct. That I'll send a copy.
Order.
It's not been uploaded. From what I understand, my lords, it's not been uploaded yet. The minute it's uploaded, we'll make sure.
Very well. Then you instruct your junior to file that order.
We'll make sure. We'll make sure.
that order was pertaining to his traveling abroad, my lords. Permission seeking travel abroad, my lord. That was the prayer in that petition, where he was already granted bail. There were certain conditions which required to be modified. That was what was heard yesterday. Now, as far as the present matters are concerned, my first submission is this, my lords. If a FIR discloses a cognizable offence, it cannot be quashed. At the threshold, the investigation is pending. We are at the nascent stage of investigation.
This argument was made on the last occasion.
Yes.
If any new thing you want to add, please add it.
Therefore, I'm pointing out from the FIRs how a cognizable offence is made out.
Yes. These are the points taken, argued, heard by this court.
Yes.
Any new point, if you want to urge, please urge it, Mr. Raju.
Now, kindly look, I'm now arguing on facts, how the offences are made out. This I never argue. Now look at each of the FIRs, my lord. The FIRs. First is Vishnupur Police Station 668.
When it was filed, Mr. Raju, this complaint,
Complaint was filed on 13 June 26.
all are post declaration of result.
Yes.
So on this premise, also already court has passed an order on 21st of May permitting the granting the petitioner interim protection. So the complaints which are lodged after declaration of result on 4th of May 2026, that will be considered, but no custodial interrogation. Court will have already has considered similar issue in FIR 75 of 2026.
I'm obliged, my lord. My lords may kindly appreciate. The
Yes.
prayer is for quashing. The prayer is not for anticipatory bail.
Yes.
Custodial interrogation assumes some significance. In a prayer for quashing, custodial interrogation would, according to my submission, would not be relevant, because prayer is not that I should be granted bail, anticipatory bail. It is only when anticipatory bail.
Show me any FIR or complaint prior to 4th of May 2026. I want to hear you on this issue first.
There is no there is no
Yes.
prior to. My lords are right. All are
Yes.
subsequent to polls results.
Yes, all are post declaration
all
of
three are-
assembly election of 2026. So this will be considered as it was decided in a previous matter at the interim stage on 21st of May.
So may I take it that what the court is considering is that no custodial interrogation in the quashing petitions will not be allowed? Is it that what is being contemplated, so that I may formulate my arguments in those lines? If the proceedings are going to be quashed, there is no question of custodial interrogation.
No, court is not going to quash it. You continue with the investigation, and I will direct and ensure that the petitioner will cooperate with the investigation. But don't take any coercive steps in the meantime.
Now kindly have a look at the prayers. Now, kindly
Yes.
have a look at the prayers.
Today, court is not passing a final order quashing the proceedings.
My lords,
You investigate the case, submit a report, but don't take any coercive steps. As already this court has passed an order on 21st of May 2026, granting the petitioner interim protection.
may I only point out this, my lords? If my lords, then the
Now,
petition.
Mr. Raju, if today court refused to or declines to grant interim protection to the petitioner, then the protection which was granted in connection with FIR number 75 of Bidhannagar Cybercrime Police Station case, that will be that order will be nugatory.
My submission is this, my lord.
Yes.
My submission is that the petition itself requires to be dismissed. If
Yes.
the petition itself requires to be dismissed, there is no question of granting any interim relief. That's my
Yes.
first submission. And there are reasons which were submitted earlier on the earlier date why the petitions are required to be dismissed. Now, therefore, if the FIR makes out a cognizable offense, there is no question of quashing the FIR. He doesn't. His petition is not even argued that the offense is not made out. As far as I know, no submission was made that the FIRs do not disclose a cognizable offense. That submission was not made. That is not his case.
It is my case. I specifically took each FIR and I said there's no offense made out. Forget about cognizable.
You never argued. I am sorry. You never argued this point. You never argued it. You never argued. You never formulated this point. You never elaborated on this point.
Elaborated, maybe not. Yes.
No, you did not argue, sir. You never argued this point. And he never argued. I said on the last date also, he never argued that no offense.
If FIR discloses cognizable offense, in that event, you investigate the case.
That event, I will. Of course, I will. I am duty bound to investigate.
Case, and court is not passing an order, thereby restraining the investigating agency from investigating the case. But thing is this, that petitioner has to cooperate. And if that cooperation is ensured by the date of the order which is to be passed by this court, then where is the difficulty?
I am not clear. I'm sorry, my lord. I'm not clear.
Yes.
Intention is, if the offense is disclosed, then the quashing petition does not survive. If the quashing petition does not survive, there is no question of granting him any interim relief. And if at all he wants any interim relief in the nature of no causative steps, or in the nature of giving him anticipatory bail, or in the nature of not custodial interrogation, he will have to file an anticipatory bail application. This is not the petition.
Yes, Mr. Raju, point noted. Any other point?
Yes, there are several points. Therefore, let me now take my lord through the FIRs, which were contents of which were not read when it was argued, to show that offense, cognizable offense, is not made out. My specific cases, each of these FIRs make out a cognizable offense. Now, kindly look at the FIRs and look at the cognizable offenses which are made out, my lords.
With regard to FIR, detailed submission was made, Mr. Raju.
That no
Submission was. I have heard you last occasion.
No,
With regard to FIR, FIRs were placed. Matter was heard in detail.
When I ended my submissions, I said
Yes.
I have.
Now I will not permit you to open the case again. No, I have heard you more than 1 hour.
With respect, but I have not opened as far as the FIRs are concerned.
Yes. There's a detailed submission made. Only if anything is left, now I will not permit you to open the case again. No.
I'm not opening the case. I will not argue, which I did not argue on the earlier occasion. I am arguing only this, that the FIR disclosed a cognizable offense. Now let me point out the facts in the FIR which disclose a cognizable offense. What was argued by the other side was there is a delay. What was argued was mala fides. It was never argued that there is a cognizable offense is not disclosed.
Yes. Very well. Come to FIR.
Yes, my lords.
Which
Now,
FIR you want to rely upon?
FIR, my lords. Page 136 to 158 is a written complaint. And there's a laptop.
Page
136 to 158.
It's a Kalitala case.
Yes.
140 of 26. My lords have got it. It is the case pertaining to illicit mining. Get the page 136. Illicit mining operation in MLA Lake and in the adjoining critical wetland clusters located at Shankarpata main road. So
It is FIR dated 16 June 2026.
16,
Yes.
16 June 2026.
Yes.
yes, my lord.
Kalitala Ashuti.
Mr. Raju, by whom this FIR was lodged?
By one Abhijit Das.
Who lost the election twice to the petitioner.
Maybe. Therefore,
And what are the period during which this alleged offense was committed?
but that, my lord, look at the FIR.
So whether these are not relevant considerations at the time of passing an interim order?
I am not saying about the, I am saying interim order can be passed. I am arguing the main petition. If the offense is not made
Very
out,
well,
if the
today, Mr.
petition-
Raju, court is not hearing this matter on affidavit. So your main prayer of quashing will not be considered at this stage. Court is contemplating to pass an interim order, and court will direct the parties to exchange affidavits. And court will permit the court will permit the investigating agency to investigate the case in accordance with law.
May I only point out this, my lords.
Yes.
For passing of an interim order, there must be prima facie case. You must, the first requirement is prima facie case. If my lords are not considering the main prayer, whether there's a prima facie case, then no interim relief can be granted with
Yes.
greatest respect. Prima facie, he must demonstrate a prima facie case.
So let us see the outcome of the investigation. Let us see the outcome of the investigation.
Greatest respect, my lord, with greatest respect.
There is no charm in taking the petitioner into custody.
The cart before the
Let us
horse,
see
my
the
lord.
outcome of investigation.
This is not an anticipatory bail matter. This is a quashing matter. Therefore, you must
Yes,
first
yes.
make a
Yeah,
prima
at
facie
least that
case
is
for quashing.
at least this court is aware of this. Yes.
My lords, may kindly, he could have filed an anticipatory bail and prayed for no coercive steps. He has come for quashing. If he has no case for quashing, where's the question of granting any interim relief? My submission is, he has absolutely no case as far as quashing is concerned. Matter may be filed, there may be a delay in filing. That is no ground for quashing if a cognizable offense is made out.
Yes, point noted. Any other point, Mr. Raju?
Now, I look at section 468 of the CRPC, which is new section is what?
Any other point, Mr. Raju?
This is offense punishment with more than 3 years.
Yes.
Therefore, there is no limitation. Therefore, delay can't be a ground for quashing. Delay can't be a ground for quashing.
Yeah, that point was taken relying upon judgment. That there is no point of malafide or delay in the matter of in criminal jurisprudence.
Malafide is a different point, brother. Malafide is a different point. My submission is this, that delay can't be a ground for quashing, because unless it falls under the one of those provisions of 468, which is up to punishment with maximum 3 years imprisonment, delay can't be a ground for quashing. It may be a good ground for getting anticipatory bail. It definitely can't be a ground for quashing. So my submission is that mere delay in filing FIR can't be a ground of quashing. Delay has explained his part in power. Nobody would take the complaint. Therefore, my lords, delay in this particular case would, though it is not relevant, would still be is explainable because his party was in power and nobody would register the FIR. Secondly, my lord, this is a case where national resources are plundered. This is a case of illicit mining and prima facie offences which are serious economic offences have been made out. Now, kindly have a look, my lords. Kindly have a look at Tara Datta's case, my lord, 2000, volume 1, SCC 230. Para 5 and 6. Punishment is more than 3 years. They can't be quashed on the ground of delay. It cannot be. That is what the legislature said. Ultimately, it is for the complainant to explain the delay. Therefore, delay merely because it is a 2017 incident filed in 2026 is no ground for quashing the complaint. That can never be a ground for quashing a complaint, my lord. If a cognizable offense is made out, the police are duty bound to register an FIR in view of Lalita Kumari's case, 2014.
Yes, these points will be considered at the time of final hearing of this writ petition. Today, court is at the motion stage, contemplating to pass an interim order.
But my lord, my
court is not passing any order to impede the police authorities from investigating the case. So therefore, you go on with the investigation. Today, court is not passing any order in order to quash the proceedings. So there is a distinction with regard to the final order to be passed on the writ petition and the interim order which is court is contemplating to pass. So therefore, at this stage, court is not required to consider this. At the time of final hearing, court will consider these points whether it's a case of quashing or not.
May I point out, my lord? May I point out this, my lords? My lord, unless the petitioner makes out a case for quashing, there is no question of granting interim relief. Am I clear? My lord, I'm saying unless he makes out a case for quashing, he is not entitled to interim relief.
That point I have taken, Mr. Raju. If any other point is there, please. Advocate, I have heard you. Last occasion, I have heard you extensively.
And if, my lord, interim relief is granted without considering the fact that a prima facie case is made out or not, that would be amount to putting the cart before the horse. My first,
Yes,
he has the
Yes.
prima case. He has
Yes,
not
I have-
prima
Yes.
facie case for quashing.
Yes,
That's
I
my
have
submission.
noted your submission that if there is no prima facie
Yes,
case,
sir.
then there is no case of there is no question of passing any interim protection. Yes. Any other point?
Secondly, my lord, there are two judgments on which I am relying to show that the petition is non-maintainable. Petition cannot be entertained because it doesn't make out a ground for quashing. Then no interim relief can be granted. Two judgments of Supreme Court, Bharat Coking Coal 2011-14 SCC 140.
11-14.
No, problem is this, Mr. Raju, last occasion you have relied upon certain judgments.
Yes.
Now, in that event, again, I have to grant time to the petitioner to respond to these judgments. So,
Yes,
only no. For indefinite period, I will not go on
I
permit
did not complain. I did
proceedings
not
to go on.
submission.
So, therefore, don't
complete my
rely
submission,
upon
my
any
lord.
judgments further. Whatever points you want to agitate, please agitate.
But-
And the final hearing is to be taken
Yes,
at the time of final hearing, you agitate these points.
but,
Because I have already heard Mr. Shankar Narayanan, you made an elaborate submission. If any addition or alteration, please don't open the case too wide so that I can again, this court needs to hear it again. That I will not permit.
well, my lords may say so, my lord. My lords may say so.
Yes.
My lords may say so that my lords may not permit me to argue further. That I don't want to argue, my lords. My lords may say so.
Yes.
My lords may say so that my lords are curtailing my submission. My lords may say so. Then there's nothing else for me to submit. Because I never completed my arguments. I'm not repeating my arguments. I'm not repeating the judgment.
I think it's very unfair, Mr. Raju. Please don't say that.
Don't interfere, Mr. Shankar Narayan.
Multiple opportunities have been given. You have taken an adjournment for the Solicitor General, after which the Solicitor General was heard. You were heard. For you to accuse the court like this is very unfair.
I'm being curtailed. My lords may pass appropriate orders, my lords. I can't help it because my lords who wants to. I leave it to my lords, my lords.
Yes, Mr. Chatterjee.
There are several cases lodged against this person.
When these cases were lodged, Mr. Chatterjee,
Regarding the genuinity of
you are representing whom?
I'm representing respondent number 15, who has lodged two of the complaints among these 4 complaints. Now, my lord, it has fallen from your notes. And why these complaints?
You are representing respondent number 50.
15.
Just
My lord, he has lodged 2 complaints. One is of Vishnupu and one is of Kalital Ashupti. Now, my lord, the question arises regarding the genuinity of these complaints, not the timing of this complaint. Because, my lord, timing things, my lord, practicability, my lord, kindly appreciates that it has fallen from your lordship that he has lost in election twice. But, my lord, kindly appreciates once he has lost 7 lakhs of votes. Subsequently, it was found that in their jurisdiction,
So since he has lost by 7 lakhs votes, that is the reason for.
No, my lord. 7 lakhs votes. Subsequently, it was seen that in that jurisdiction, the voter number is not 7 lakhs.
That could, Mr. Chatterjee, that could have been a ground of another FIR.
My lord, it shows that
Had it been a contemporaneous complaint.
it shows that how influential he is. He's super influential. My lord, before
So that's why, Mr. Chatterjee, court is not simply passing any order, quashing the proceedings. Now, I will permit the police authorities to proceed with the investigation. But why coercive step is necessary?
My question is, if he is outside of the custody, no common and sane man will come and depose against him. This is not possible.
Now situation is changed.
My lord, changed. That's why.
If your client would have filed a complaint, if your client would have filed a complaint contemporaneously and during that period, in that event, your point which you are now agitating is germane.
My lord,
Yes.
before 4th of May, it was not possible for any common man to go and to lodge a complaint against this person. After 4th of May,
Then custodial interrogation was necessary, but now it is not necessary.
Otherwise,
Now situation is changed. Now situation is changed, Mr. Chatterjee.
that's why.
Yes. So therefore, custodial interrogation is not necessary.
No person will come forward. He's mega influential.
Due to change of political dispensation, now there is a change of scenario.
I do not know whether he will come back or not. That I do not know. For that reason, my lord, kindly do not give any interim order. Kindly do not pass any interim order. My lord, in Amphan, crores of money was looted. of money of common man that was looted. My lord, there are several.
Let him make his submission in a case, my lord.
My lord,
Not something which is not part of the case.
1 minute.
So very well, first point is influential person.
So, my lord, not only that, first,
Yes.
there is no ground.
Education.
In paragraph 3, he has stated, I found the petition is extreme. Because
Osho.
several complaints are filed against him. No, that is not true. And
Oh, na, chole jao.
I do not know how can he say that illegal misuse of state machinery. They have used state machinery illegally for 15 years, and after 4th of May, when common man got the opportunity of coming before your lordship, they have started coming, my lord, regularly. Several complaints have been lodged. Number one ground will be there is no point, no ground in this complaint why interim order will be given to him, why interim protection will be given to him. There is no reason. My lord, a man, he has come before your lordship. I am asking myself, my lord, had it been a case of a common man, had it been a case of a common man,
Yes. If it is a delayed FIR, court is interfering.
my lord,
Yes. If it is delayed FIR, court is interfering. It can be perceived the intention of the person who lodged FIR.
My lord, my case.
But even this is too early. Investigation is at the nascent stage. Court is not interfere. Will not interfere with regard to the investigation which is to be carried out by the agency. But why coercive steps will be necessary if it is assured or ensured by the dint of this order the cooperation of the petitioner.
My lord, this man was attacked on several occasions. Whenever he has done,
But now the petitioner is being attacked.
my lord, attacked, my lord. After the
So that goes to show that there is a change of scenario.
no, my lord. My client, respondent number 15.
Yes.
He was attacked, my lord, on several occasions. He was admitted in the hospital. Several stitches were there on his head. That's
No, I understand the agony. I understand the feeling of respondent number 50. But would it be the consideration at the time of granting interim protection, permitting the authority to go on with the investigation?
My lord, my humble submission will be, these should be considered as considerations for not giving him protection, my lord. Because when this man was before 4th of May, he was super influential. My client was attacked on several occasions. He was admitted in the hospital because he was raising objections against this person. Well, this is not a case that this man, he has never brought any allegation against this petitioner. No, before this 4th.
Yes.
Before 4th May also, my lord, this man, he has lodged complaints. This is not the first time that after 4th May, when situations were.
No, this court appreciates. So that's why court investigation will continue and court will direct to cooperate. Yes, you are opposing.
I am opposing.
Yes.
I do not give any protection because, my lord, he is super influential. And after 4th May also, my lord, he is influential. After 4th May also, he is influential. He is mega influential, my lord. Kindly do not give him any protection. He has already gone to America, my lord, with 25 bags. I do not know whether he will come back to cooperate investigating agency or not. Probably not. Probably he will.
That is beyond our knowledge.
Not be within my submission. But the fact is, he's still influential. Hence, my lord, kindly do not give any protection. Then my investigations will be hampered. No common man will come forward to depose against him or to give statements or evidences against him.
No, I understand the phases through which respondent number 15 and the plight of respondent number 15 which is being alleged in that perhaps the reasons for filing these complaints. So let these complaints be investigated upon.
This will be murdered, my lord. If this super influential person remains outside, my lord, he will be forced to withdraw the complaint. He will be
Now.
Still now, my lord.
Still now.
My lord. Still now, my lord. He is super influential.
Yes.
The paragraph starting with recording of.
Yes.
The name is mentioned. The name is mentioned, my lord, who would be interrogated, the particular sentence. So, my lord,
So that's why you are praying not to circulate.
not to start.
My lord, the report made over. No, my lord, may I just submit one thing, my lord, subject to correction
He's an
and
accused.
exception.
In the same case,
My lord, I am not an accused.
he's on bail in the first case.
Interim order passed on. 10th
of June.
2026.
My lord, so far, my lord, till
30th November 2026 or until further order?
Only one submission of mine can be recorded that pursuant, there was a condition of your lordship's order that I must comply with all notices. I am giving your lordship 3 dates, my lord. 18th of June, 22nd of June, and my lord 7th of July. I have annexed those also, my lord, in my can. Pages, my lord, 15 and 16.
You appeared.
I have appeared.
Yes,
and
yes. That is reflected from the report itself.
Very good, very good. My lord, that I do not know, my lord.
my lord, I have a very small submission, very short submission.
Not
Vacation intervened in the meantime. Prior to vacation, several matters are fixed. Come back on 30th November.
And I have been complying.
On 30th November 2026 or until further order, list the matter. Or until further order, whichever is earlier. Stop. Next paragraph. List the matter under the same heading for further consideration on 17th November 2026.
And my lord, it will not.
Application being Can 1.
Can one.
Application being Can 1 of 2026 seeking extension of interim order filed by the petitioner is disposed of.
I'm deeply.
My lord, I have a very small submissions, my lord. My lord, so far paragraph 32 of the order is concerned, my lord, I am entitled
No,
to get
today
the-
I will not direct to.
My lord, so far paragraph
because
32
investigation is
my
going
lord,
on.
sorry, my lord, because it has a direct bearing with my allegations.
It will not, It will not preclude my lord filing of my lord charge sheet before the learned court, my lord.
My lord, your lordship cannot say charge sheet, my lord.
Right.
Yes.
That's
Yeah, otherwise the theme
your
of the
lordship can
act,
say
my lord,
report in
entails
final
me.
form. Perhaps, my lord, subject to correction.
However, it is made clear that pendency of this proceeding shall not preclude the investigating agency to take steps with regard to ongoing investigation and to file report before the jurisdictional magistrate.
Great. Great.